Good morning to all of you. Welcome to Legal Maths by Sai Babu Sankara. In the law class yesterday, particularly in the jurisprudence class, we discussed A.K. Gopalan versus State of Tamil Nadu case where the preventive detention was discussed at length. So section 15 of the PD Act was held, so-called doctrine of severability we have discussed. Anyway, once again another such case has come and the judgment was given by Karnataka High Court. Karnataka High Court clearly stated that it is the bounden duty of the authority to give the copies of the documents regarding the details of the detention to the Detenu in the language known to him. Even High Court also says like that. Even Constitution also says like that. And the Evidence Act also, CRPC also provides the same. So if you furnish the information in a language which is not known to the accused, what is the purpose? How can he prepare the defense? This is what is stated by the Honorable High Court in the case of Mohd Shafiullah versus the DG and IGP of Police, Karnataka State and others in WHC number, writ of mandamus, number 75 by 2023, and two judges bench, Justice K. Somasekhara and Justice K. Rajesh Roy. So they allowed the habeas corpus petition, not writ of mandamus, I'm sorry. They allowed the habeas corpus petition to produce the Detenu before the court, and he was set at liberty by quashing the detention orders. How he was? The orders were quashed. Normally, I told you the example of that Parliament woman who was against whom the PD Act has been applied, and she is languishing in the jail. When once PD Act is applied, 6 months guarantee you cannot come out of the jail. But in the meantime, the important point is you have to provide the copies of the documents on which the detention order was made. Here, Mr. Shafiullah, whose case we have discussed, he is involved in 20 theft cases right from 2013. He was involved in number of crimes. Even though he is getting bail, he is not mending his way. He is once again committing the offences. Therefore, he has become a menace to the society. His activities are against to the public order. Therefore, it was decided by the government of Karnataka, or the Commissioner of Police Kolar. It happened in Kolar. DCP Kolar has issued the detention orders against the so-called, let me know that name, Mohd Shafiullah. Right? So the detention, normally he was detained under the detention order, sent to the central jail. Normally, you may be knowing, within 2 or 3 days, they have to inform the grounds of detention by supplying copies, and a board will be constituted to check up whether the detention is legal, regular or not. Right? So this is the thing. So according to Section 3, Clause 3 of the Gundas Act, because the Act is very lengthy, prevention of the activities of bootleggers, all these things are better to know that Act also. I will tell you the name of the Act. Yes. Prevention of the dangerous activities of bootleggers. Bootleggers means Dongasaragasi batch. Drug offenders, NDPS Act. Then gamblers, Packard batch. Gundas, immoral traffic offenders, IT Act. So prostitution, other thing, human trafficking. Then slum grabbers, important. Slum grabbers. And video or audio pirates. Piracy, it has become a menace. Act 1985. We can call it as a Preventive Gunda Act. Even in Andhra Pradesh also it is there. This is Karnataka State Act. Right? So they arrested him as per the so-called Section 8 of the Gundas Act And please remember Article 22 Clause 5 of the Constitution of India requires that please remember, he has to be supplied with the copies of the documents in the language which is known to him. This man is a student of Arabic school. As a student of an Arabic school and who has studied the first language in Arabic language or Urdu. So you can't consider him as well educated. You can't consider him as he is having knowledge in Urdu, English and Kannada. What happened is the police supplied him the copies in Kannada as well as English, but not in Urdu. He raised objection, his advocate raised objection that the documents supplied to the Detenu were English and Kannada, and the Detenu, being a student of Urdu medium school who has studied till 2nd standard, was not familiar with either English or Kannada. Finish. Only on that ground the matter was quashed. See, you must be very, very careful. No doubt he may be a thief. He may be anti-social element. He should not stand in the society, but still you have to legally be very, very cautious. Section 3, Clause 3 of the Gundas Act. So please remember, within 21 days, the Detenu has to be examined by the so-called board. Of course, board has examined him. Ultimately, the board held that it is viewed that there are anomalies in the materials provided also, and basically it is glaringly observed that the records are not in the local language, and the records are also not clearly visible and legible. The result is he was honorably sent out from the jail. So this happens. So please remember, so whenever you file a case, it must be pakka. Otherwise, the result will be like this. So read the case law and enrich your legal knowledge. Thank you.